Fitness to proceed. Definitions. As used in this article, the following terms have the following meanings. 1. Incapacitated person means a defendant who as a result of mental disease or defect lacks capacity to understand the proceedings against him or to assist in his own defense. 2. Order of examination means an order issued to an appropriate director by a criminal court wherein a criminal action is pending against a defendant or by a court evaluating the capacity of an alleged violator in a parole revocation proceeding. Pursuant to subparagraph Z of paragraph F of subdivision 3 of section 259I of the Executive Law, or by a family court pursuant to section 322.1 of the Family Court Act wherein a juvenile delinquency proceeding is pending against a juvenile, directing that such person be examined for the purpose of determining if he is an incapacitated person. 3. Commissioner means the State Commissioner of Mental Health or the State Commissioner of Mental Retardation and Developmental Disabilities. 4. Director means the director of a state hospital operated by the Office of Mental Health or the director of a operated by the Office of Mental Retardation and Disabilities, or b. the director of a hospital operated by any local government of the state that has been certified by the Commissioner as having adequate facilities to examine a defendant to determine if he is an incapacitated person, or c. the director of community mental health services. Certified psychologist means a person who is registered as a certified psychologist under Article 153 of the Education Law. 7. Psychiatric examiner means a qualified psychiatrist or a certified psychologist who has been designated by a director to examine a defendant pursuant to an order of examination. 8. Examination report means a report made by a psychiatric examiner wherein he sets forth his opinion as to whether the defendant is or is not an incapacitated person, the nature and extent of his examination, and, if he finds that the defendant is an incapacitated person, his diagnosis and prognosis and a detailed statement of the reasons for his opinion by making particular reference to those aspects of the proceedings wherein the defendant lacks capacity to understand or to assist in his own defense. The state administrator and the commissioner must jointly adopt the form of the examination report, and the state administrator shall prescribe the number of copies thereof that must be submitted to the court by the director. 9. Appropriate institution means a hospital operated by the Office of Mental Health and Disabilities, or b. a hospital licensed by the Department of Health which operates a psychiatric unit licensed by the Office of Mental Health, as determined by the Commissioner, provided, however, that any such hospital that is not operated by the state shall qualify as an appropriate institution only pursuant to the terms of an agreement between the Commissioner and the hospital. Nothing in this article shall be construed as requiring a hospital to consent to providing care and treatment to an incapacitated person at such hospital. 20. Fitness to proceed. Generally 1. The appropriate director to whom a criminal court issues an order of examination must be determined in accordance with rules jointly adopted by the Judicial Conference and the Commissioner. Upon receipt of an examination order, the director must designate 2 qualified psychiatric examiners, of whom he may be 1. Proceed. Generally 1. The appropriate director to whom a criminal court issues an order of examination must be determined in accordance with rules jointly adopted by the Judicial Conference and the Commissioner. Upon receipt of an examination order, the director must designate 2 qualified psychiatric examiners, of whom he may be 1, to examine the defendant to determine if he is an incapacitated person. In conducting their examination, the psychiatric examiners may employ any method which is accepted by the medical profession for the examination of persons alleged to be mentally ill or mentally defective. The court may authorize a psychiatrist or psychologist retained by the defendant to be present at such examination too. When the defendant is not in custody at the time a court issues an order of examination, the court may direct that the examination be conducted on an outpatient basis, and at such time and place as the director shall designate. If, however, the director informs the court that hospital confinement of the defendant is necessary for an effective examination, the court may direct that the defendant be confined in a hospital until the examination is completed. 3. When the defendant is in custody at the time a court issues an order of examination, the examination must be conducted at the place where the defendant is being held in custody. If, however, the director determines that hospital confinement of the defendant is necessary for an effective examination, the sheriff must deliver the defendant to a hospital designated by the director and hold him in custody therein, under sufficient guard, until the examination is completed. 4. Hospital confinement under subdivisions 2 and 3 shall be for a period not exceeding 30 days, except that, upon application of the director, the court may authorize confinement for an additional period not exceeding 30 days if it is satisfied that a longer period is necessary to complete the examination. During the period of hospital confinement, the physician in charge of the hospital may administer or cause to be administered to the defendant such emergency psychiatric, medical or other therapeutic treatment as in his judgment should be administered. 5. Each psychiatric examiner, after he has completed his examination of the defendant, must promptly prepare an examination report and submit it to the director. If the psychiatric examiners are not unanimous in their opinion as to whether the defendant is or is not an incapacitated person, the director must designate another qualified psychiatric examiner to examine the defendant to determine if he is an incapacitated person. Upon receipt of the examination reports, the director must submit them to the court that issued the order of examination. The court must furnish a copy of the reports to counsel for the defendant and to the district attorney. 6. When a defendant is subjected to examination pursuant to an order issued by a criminal court in accordance with this article, any statement made by him for the purpose of the examination or treatment shall be inadmissible in evidence against him in any criminal action on any issue other than that of his mental condition. But such statement is admissible upon that issue whether or not it would otherwise be deemed a privileged communication. 7. A psychiatric examiner is entitled to his reasonable traveling expenses, a fee of $50 for each examination of a defendant and a fee of $50 for each appearance at a court hearing or trial, but not exceeding $200 in fees for examination and testimony in any one case. Except that if such psychiatric examiner be an employee of the state of New York, he shall be entitled only to reasonable traveling expenses, unless such psychiatric examiner makes the examination or appears at a court hearing or trial outside his hours of state employment in a county in which the Director of Community Mental Health Services certifies to the fiscal officer thereof that there is a shortage of qualified psychiatrists available to conduct examinations under the criminal procedure law in such county, in which event he shall be entitled to the foregoing fees and reasonable traveling expenses. Such fees and traveling expenses and the costs of sending a defendant to another place of detention or to a hospital for examination, of his maintenance therein and of returning him shall, when approved by the court, be a charge of the county in which the defendant is being tried. (730.30) Fitness to proceed. Order of examination 1. At any time after a defendant is arraigned upon an accusatory instrument other than a felony complaint and before the imposition of sentence, or at any time after a defendant is arraigned upon a felony complaint and before he is held for the action of the grand jury, the court wherein the criminal action is pending must issue an order of examination when it is of the opinion that the defendant may be an incapacitated person. 2. When the examination reports submitted to the court show that each psychiatric examiner is of the opinion that the defendant is not an incapacitated person, the court may, on its own motion, conduct a hearing to determine the issue of capacity, and it must conduct a hearing upon motion therefore by the defendant or by the district attorney. If no motion for a hearing is made, the criminal action against the defendant must proceed. If, following a hearing, the court is satisfied that the defendant is not an incapacitated person, the criminal action against him must proceed. If the court is not so satisfied, it must issue a further order of examination directing that the defendant be examined by different psychiatric examiners designated by the director. 3. When the examination reports submitted to the court show that each psychiatric examiner is of the opinion that the defendant is an incapacitated person, the court may, on its own motion, conduct a hearing to determine the issue of capacity, and it must conduct such hearing upon motion therefore by the defendant or by the district attorney. 4. When the examination reports submitted to the court show that the psychiatric examiners are not unanimous in their opinion as to whether the defendant is or is not an incapacitated person, or when the examination reports submitted to the superior court show that the psychiatric